I no longer want to be on housing, and if I have to lose it, I will. I asked Mr. Henry, as well as Christina, for a lease so I could register my son for school. Never received one.
Eviction court opens with raw reality. A single mother admits choosing transportation over rent, while a landlord demands possession. Unpaid months, a housing voucher, and strict legal rules collide fast. One mistake can flip this entire case upside down. Watch closely. Details decide everything here. Subscribe, like, and share for more courtroom drama.
Cause number of today's case is J2V25-0722. This case involves the address in question. You, the plaintiff, Mr. Henry, filed a petition, which is a sworn complaint in my office, indicating that the defendant defaulted in the terms of her lease by not paying rent for the months of September and October. At the time you filed this case, you swore to me that she owes you $1,144. And these are the grounds for the eviction. With that being said, I'm going to have both parties sworn in and we will proceed on with today's case. Please raise your right hands. Do you solemnly swear and or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, so what's going to happen next is I'm going to give you, Mr. Henry, the opportunity to speak first. It's going to be up to you to provide proof to me that the defendant did default in the terms of her lease and that you did everything you were legally supposed to do prior to the case getting to this point. While you're speaking, Mr. Henry, I'm going to ask that you, Ms. Johnson, refrain from interrupting him. I need to make sure I hear everything that Mr. Henry is stating. Okay, Ms. Johnson?
Yes, sir.
Okay, and then afterwards, once you're through, Mr. Henry, I'll consider your case to be presented. You're at rest. And then afterwards, you, Ms. Johnson, I'm going to give you the opportunity to defend yourself. It's going to be up to you to provide proof to me that you should not be evicted based on the complaint or whatever reason you deem necessary as a defense. And while you're speaking, I'm going to ask that you, Mr. Henry, refrain from interrupting her because I need to make sure I hear everything that she's saying. Okay, Mr. Henry?
Yes, sir.
All right. With that being said, Mr. Henry, you may proceed with the case against the defendant. Go ahead.
Thank you. Yeah, I'm filing eviction course for eviction for a non-payment of rent for Miss Johnson. Like you said, for the months of September, October, and we have received no payment for November as well. Miss Johnson has been, I don't know if I can add November too or not, but Miss Johnson has been a tenant of ours for many years. Miss Johnson is a recipient of a housing voucher. She is on housing, so housing pays a portion and still continues to pay a portion. I reached out to her caseworker initially. They said it's out of their hands to just file eviction, but that she would lose her voucher. Last week I called Miss Breeze and said, hey, I know you've got a child. I don't want you to lose your voucher. I know you want to move. And she elected to said, I'm going to show up to court and deal with the eviction. She didn't plan to pay for November either. And so that's what I'm bringing. She's not been paying her portion. This is the third month, Your Honor. And this seemed like the next step. Again, Ms. Johnson has been a tenant of ours for many years, and I have many housing recipients, and this was the only step to move forward. So if there's another step that I don't want to put her in a bad spot and make her not have her voucher, but this was what was advised to me from Christina Miller at Waco Housing Authority. So that's where we're at. I'm requesting.
All right.
Sorry.
You indicated that the defendant didn't pay her portion of the monthly rent for the months of September, October, and now November. But according to your lease, it's $1,600 per month. How much of that is the tenant responsible for?
Unfortunately, I can't tell you that. I am traveling for a funeral, and I do not have her prorated portion. I could look it up on my email if you could let me put the Zoom on hold. I do have it on my phone, but I don't have it in front of me.
I can get that a little later. Do you know
Okay.
how much but right now you don't know how much right off top, you don't know how much you're getting from housing each month.
No, I do. Again, I have it in my inbox. I could pull it up quickly and tell you what her prorated portion is, or she may know off the top of her head. But I don't know that. I'm sorry, I don't have that ready.
Okay. Also, you filed with the court. It says rental increase request form. This was dated March 22nd, 2024. The current rent at that time was 1,600, but is the rent now 1,750, or what is the rent now as of today?
Again, I'm sorry, Your Honor. I don't. I could I could look up her. I could log into the portal quickly and tell you. I don't have that printed in front of me. It's all on my phone or at my home on my desktop.
I
Um,
guess we'll have to get that later. So let's talk about the notice to vacate. Um, you gave the tenant, was it a 3-day notice to vacate, 30-day notice to vacate? What type of notice to vacate did you give her?
three-day notice.
Okay, 3-day notice to vacate, and that was delivered to her on September 18th. Is that right?
That's correct.
And that was
I
hand
believe.
delivered to the tenant?
Yes, sir.
Okay.
Yeah, I learned. I've learned my lesson from your court a couple years ago, where we put it in the mailbox, and you advised me you either have to hand deliver it or tape it to the inside of the door.
Gotcha. That's true. That's true. All right. Okay. So I have a lease. You gave her a 3-day notice to vacate. Is it reference to the address at 2205 Alexander Avenue, Unit A? Um, the one thing that I can see on this one, you don't have to do this verification of compliance with the moratorium. That's something that's not owed. But seeing that she is on housing, she does have some type of protections due to the CARES Act. That's something that I don't know if Housing Authority went over that with you, but she does have certain protections, seeing that she is on housing, and we'll get a little more into that a little bit later. Um, so the lease that you gave me looks like, as you mentioned before, it's a fairly old lease. This lease is dated February 1st, 2023. So I'm assuming you never renewed the lease. It's just month to month.
Yeah, it goes to month unless housing requests a fresh one. Which so they did request. There's additional backstory that so housing when her term renewed, they did request a new lease. We did not give her a new 1 year lease because of some damages. And so the agreement between housing, myself, and Miss Johnson was to write a contract for her to repay for the damages. And then we would issue a new lease, or I would authorize her move out. She was requesting one of the two. She either wanted a new lease or a move out. And we did not issue that. So again, Miss Miller, Christina Miller, Housing Authority, said that it would just have to stay where it's at until she fulfilled her end of that contract. She never signed that repayment contract, so the lease has continued month to month, which I believe at the end of that contract it does state if not renewed, it automatically goes to a month to month
Did
agreement.
did Miss Miller provide any of this to you in writing in an email form, showing indicating everything that you're stating?
We some of that correspondence is in email. Yes, the final agreement was actually a call where Miss Johnson was in Christina's office, and she had her in the office and then called me, and we had a long discussion over that. And Miss Johnson knew that housing would not issue her a new voucher um, without, and I do have an email stating that it was either from Olivia or from Miss Miller that they would not issue her a new voucher until the known and inspected damages were indemnified. Or and so that's the reason we don't have an updated lease.
Okay. And the only reason why I asked about that, because you're quoting Miss Miller, and if you don't have anything in writing to support your quote, you really can't use it in court. It's considered hearsay. That's why, strongly encourage you to make sure that you get everything in writing as much as you can. Therefore, you'll be able to relay that information to the courts in the event that it's challenged in any way, form, or fashion. That's all. All right. Uh, let's move on to the defendant. I'm going to give you, Miss Johnson, the opportunity to defend yourself. You've heard the case against you. You received documentary regarding this case, which is the complaint, the petition, and the supporting documents. Here's your opportunity to defend yourself. Go ahead.
Yes, sir. I am agreeing to um his term of eviction. I didn't pay September or October's rent. I lost a job, and as being his tenant, I'm not always able to express personal things to him without it going to another level. So I didn't express that to him. I expressed it to housing. So it was more like my bills are getting cut off, paying him rent and late fees. And even though the rent was due, the rent was 372 is my portion. Um, housing pays the remainder. Um, even though I know that it was 372, I didn't always have that at the beginning of the month. So yes, I paid late fees. Things started to take a fall. Late fees started to get outrageous. I lost the vehicle. So I decided, is it the livelihood of me being a mother, needing a vehicle, or paying Mr. Henry? So I decided to get me a vehicle, um, opposed to paying Mr. Henry. I did state to Mr. Henry that I would pay him the month of September after the 3-day eviction was given. I decided again to get a vehicle instead of doing that. And I do agree with that. As far as the damages, it was a fire and it was not proven from the fire marshal or his electrician that it was my fault. So when I spoke to housing initially in regards to it, before we even moved everything over to Christina Miller, housing told me if the fire marshal or nobody can prove that it's your fault, it's not. So I was told I could have moved out of his property and paid him for the appliances in 12 months. This was after we went through Olivia and several other people. The inspector came out. I did repaint the living room. I did refix some of my damages that I caused, which was in the lease. But from the 2023 lease to 2025, leases changed. So from my understanding, they were 12-month leases through housing. So I never knew it changed month to month because I haven't had a lease since 23. So with that being said, I didn't agree. I did not agree in writing. I did not agree over the phone call with Christina Miller that I would pay the damages. Because the question was, okay, what about the things that I have repaired and the pictures I have sent in? What happens to that money? Or what about the security deposit that he can keep to pay what is owed? My security deposit was $1,350. Nobody, it was like, well, that's his. Christina Miller said, as I agree with him, it's his property. We don't have anything to do with that. We're just housing. So that's when the eviction came about. But I tried to do this the right way. I talked to housing several times because I am on the program. So I was going off of their guidelines, not Mr. Henry's. Their guidelines to what I needed to do on my end in regards to keeping my voucher. When Christina decided to agree with Mr. Henry in regards to damages and back owed rent, I stated to Christina, I no longer want to be on housing, and if I have to lose it, I will. I asked Mr. Henry, as well as Christina, for a lease so I could register my son for school. Never received one. I stated to Mr. Henry when he made the phone call last week in regards to am I going to continue to go to court or am I going to pay him? You're saying the livelihood of my child. but you wouldn't give me a lease to register my child for school. That's education. You wouldn't even give me paperwork stating that I stayed on the property to register my son. So I had to go a whole nother way to get my son registered for school. And I stated to housing, if I had to lose my voucher, I was willing to do that. So that way I can continue to live as a parent and go ahead and do what I need to do for my child, because it's very complicated being a tenant of Mr. Henry's.
This is where emotion peaks. Miss Johnson explains lost work, fire damage disputes, and choosing her child's stability over payments. The judge listens carefully, separating sympathy from law. Admissions under oath matter. Viewers, ask yourselves, does hardship excuse non-payment, or does responsibility still control the outcome in eviction court?
Okay. So heard several things. You mentioned the fire marshal. So did you get a report from the fire marshal indicating, exactly the cause of this fire and whether or not you as a tenant were responsible for the fire?
No, sir. They said that I would have had to call the day that the fire happened, and they would have had to come out to verify then. So it
O-
was too late. So they never did anything.
Okay. And so housing, from what I'm hearing, housing is basing their decision on what they received, and it's pretty much verbal confirmation from Mr. Henry about the damages to his units over there.
And they also have the pictures because I
Okay.
sent them pictures.
There's a you're renting how many duplex? How many units is it in this duplex over here?
It's
It's
two.
just two.
Two.
Oh, I'm
Okay.
sorry. I thought he was talking to me.
All right. So you got two units. You're renting one of those units, and so the other unit is damaged too, I assume, due to
No,
fire.
sir.
It's just yours.
It was like the microwave is over the stove, so it was more
Mhm.
like the microwave caught, and then it was smoke on the ceiling. And the only thing that stopped working on the stove was the oven, but the stove top still worked.
Okay.
And when I called somebody out, they said if I would just replace the back panel of the stove, it'll still work. The oven will come back on. So it was no need to replace the whole stove.
So you're I guess so now let me ask you this, Miss Johnson. Are you still staying there at this unit?
Yes, sir.
Okay, so you're still staying there and you don't have a lease, you're month to month, you're at risk of losing your housing voucher, which you acknowledge the housing authority, you're willing to lose your housing voucher. Um, okay, all right. And you're willing to lose your housing voucher because you don't want to pay for the damages. Is that right?
It's not necessarily I don't want to pay for the damages. Um, what does my 1350 cover?
So let me just explain to that. So the deposit, legally, the deposit, unless your lease specifies otherwise, the deposit is supposed to cover any damages to the unit that you caused during your tenancy. So once you move out on good terms or whatever it is, you're supposed to notify the landlord that you moved out, clean the house up best way you can, the whole 9 yards, and then afterwards, your landlord is supposed to send you a itemized statement deducting any damages to the home. And the damages that they can legally deduct is, anything that's not normal wear and tear. So if it's a small hole, a little bitty hole that you might have hung a picture up, that's not really, normal wear and tear. But if it's a real big hole, or if there's damages as we're talking about to the appliances that was there whenever you moved in, then they're supposed to deduct that from your deposit. And if there's anything remaining, they're supposed to send that to you. And so they're supposed to have your contact information, whole 9 yards. So the correct move out procedures, the way I see it, a tenant moves out, make sure the landlord knows that they've moved out, and then the landlord has their contact information. And some people do a walkthrough. And therefore everything is supposed to go as planned. Now, that is what the intent of the security deposit. All right. That's the intent. Now, again, if your lease specifies otherwise, that's the intent. You have some leases, they might say something totally different. And if the tenant and landlord agree to that in the lease, then it's a binding agreement. All right.
Yes, sir.
All right. So that's the lesson in regards to deposits. So next question. You are on housing, correct?
Yes, sir.
You received a 3-day notice to vacate.
Yes, sir.
What are your future plans in regards to this unit?
Are you speaking to me or Mr. Henry?
You plan on because you hadn't paid the rent and you're here in court. Some people they say, hey, I plan on moving out, whole 9 yards. What are your future plans after today?
Moving out.
When?
Um, I think I would need until Monday.
Okay.
And also, when the fire happened, I did send Olivia at housing the pictures and the email in regards to the pricing of the appliances that I was agreeing to pay for in April initially. So I do have emails and I do have the pictures and I do have the cost of them that I was initially sending in April to pay him before we got this far to eviction court.
Yeah. So this is where we are with this particular case. Oh, I'll start with you, Mr. Henry. Just ask a couple of questions. Did you know that tenants on housing are protected underneath the CARES Act?
I I was not aware. However, when I reached out to Miss Miller about her not paying her portion for multiple months, and she said, "Hey, you've got to send it to the portal, file the eviction. That's the first step." Um, she did say that after that is finalized, and if there's a move out, there's stuff that I have to do so that they quit issuing payment to me after she moves out. But as far as additional paperwork on their end, she did not say anything to me. But I have never evicted anyone on a voucher because frankly they don't want to lose their vouchers, so we always figure something out.
So, housing authority, this is really, 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 um, it's tough. Um, the CARES Act, uh, this is how the CARES Act protects tenants. And Ms. Miller, she was right, but she didn't tell you everything. And a lot of times, if you don't ask, they assume. I know Miss Miller. Went to school with her brother. She's very knowledgeable. But again, if you don't ask the right questions, they won't tell you everything. So the CARES Act, this is what the CARES Act states. The CARES Act states that if a landlord seeks to evict a tenant that is protected for non-payment of rent, keyword, this is just for non-payment of rent, the landlord must give the tenant a 30-day notice to um, move out or to, last time I read, cure the default. So that they get certain protections. And that 30-day notice has to be done before a landlord can take the next legal action against them.
And can I ask you something? I'm sorry, I cut you off.
No, go ahead.
So we waited we waited over 45, I believe 50 days from when she received it. We waited till the next month. She didn't pay once again. the filing in your court wasn't until um, mid or late October, if I believe. So I'm not trying to argue or make a technicality, but as far as her notice and the time we gave her until we actually filed the eviction was well beyond the 30 days that she needed, even
Well,
though the
actually, Mr. Henry, let's again. It's this right here. This CARES Act is. I don't. I'm not trying to get in trouble with the feds. I'm gonna tell you that now. So I understand what you're saying. Listen to me. I understand what you're saying. You gave her a 3 day notice, but you waited actually 29 days before you filed it. So, technicality. You gave it to her on the 18th. You don't include the date that you gave it to her, which is September 18th. You cannot include that day. So you start counting the next day in regards to her 30-day notice to vacate. I want you to learn from this, Mr. Henry, because one thing I don't want you to do is not have to face any wraths by the federal government because you didn't do what they're requiring you to do as a landlord that has a tenant on housing. Okay? So I understand your dilemma. I understand it wholeheartedly. But not only do I have to make sure that the CARES Act is in compliance, but you do too. All right.
um,
I want to make sure that you're aware of that. Now, with that being said, you gave her the notice, a 3 day notice on the 18th of September. You don't count that day. You start on, and so starting the 19th of September, she had 3 days to move out. That's what you gave her. I understand you waited, but you did not give her a 30-day notice. It's not what you did after the notice, it's what you gave her, and did you comply with your own notice and do it everything legally? That is the problem that we have. Now, here's the thing. Here's the thing. Um, is she delinquent in back rent for 3 months? Yeah, she is. Is she protected underneath the CARES Act? Yes, she is. And to you, Ms. Johnson, you stated under oath that you're going to move out at least by Monday. And so here's the thing. If you want to keep your voucher, you get this man his apartment. Now, whatever money you owe him, you're still going to owe him because he's going to report that to housing. And yeah, you're a single mother and you say you don't care about housing, but it's a benefit to you and your child. And so you better do whatever you can to keep it.
Yes, sir.
That's going to be the key. All right.
Yes,
Now,
sir.
Here's the shocker. The judge dismantles the landlord's case not over rent, but procedure. A 3-day notice doesn't satisfy CARES Act protections for voucher tenants. Waiting longer doesn't fix it. One technical mistake outweighs 3 months unpaid rent. This is where federal law blindsides landlords
Yes, sir.
hard.
I trust you're gonna do the right thing and give this man his house back, his unit back, and whatever damages that was to that unit should be deducted from that deposit, and whatever's left should be given back to you. But it's only if you do what you swore to me that you were gonna do, which is get out of that house.
Yes, sir.
Understood?
Yes, sir.
Okay. So with that being said, I have no other recourse but to rule in favor for the defendant because the CARES Act was not complied with. That is the only reason why I am ruling in favor for the defendant. Now, Mr. Henry, I understand your concern and I see the expression on your face. If you believe that you should have won this case, you do have the right to appeal, and it's going to be up to you to prove to the higher court that the CARES Act doesn't apply. That's going to be the key. So you have that option. If you want to appeal it, pay a $500 appeal bond, pay your court costs. I'll send it to the higher court. You prove your case to the county court of law judge that the CARES Act doesn't apply. That's your choice. But
can I
as it stands right now, CARES Act applies. I have to rule in her favor only because you did not comply with the CARES Act. And she swore to me under oath that she's going to give you your property back and whatever remaining balance between you and housing, the whole 9 yards. Once she does move out, you do have to get with housing, go through all those procedures so they can stop making payments to you. But they've already paid you for November. That means that she's still protected. Now, if you would have terminated, meaning if you would have said, you know what, I'm not renewing the lease at all. This contract would have never stood the whole 9 yards. Then that's totally different. She wouldn't have been protected underneath the CARES Act because her housing voucher would have been terminated. Totally different scenario. That didn't happen in this case. I'll give you a few words, but it will have no impact on my judgment. I'm telling you. All right.
No, yeah,
Okay.
you've got to, do what you have to do. I'm not upset. I'm not upset at all. I'm not upset with you. It does seem like loopholes, not loopholes, but stuff like this does tend to find its way into, it seems like the burden of proof and the burden on the plaintiff or the landlord in these cases is pretty astronomical, and the tenants a lot of times can get away with quite a bit. But anyhow, I understand. I will say that I've been a landlord with housing now for almost 10 years. I've done dozens and dozens of them. Um, I have never been told, nor is there anything in the contracts with which we sign with them that says anything about this. So that may be something that needs to be addressed with the Waco Housing Authority, because it's unfortunate that the landlord has to deal with this when it seems like a duty of theirs to.
Inform.
There's nothing in my contracts that says anything about cares. They just they
Doesn't.
just dish out the voucher and make you wait 60 or 90 days to get your first payment, and then unless they have an inspection, you don't hear from them. I've never heard of this in my life. So
I'm
anyhow,
I'm I'm going to give you I want to get in contact with TDHCA. That's the Texas Department of Housing and Development. Getting their information is there. Get in contact with them. They'll be able to give you a little more information about it. Your housing contract is not going to state so in there because this is a federal act that is not going to be a part of their lease or their contract with you. So it's not going to say so in there, and they cannot give you legal advice. They can only explain procedures. So you could ask them an open-ended question like, "Hey, I was told the CARES Act applies. Am I required to give tenants a 30-day notice to vacate?" And more than likely, they're going to say yes. If
understood.
it's if it's for non-payment of rent. Now, if it's for anything else, you're not required to give them that 30-day notice. Now, here's what I'm gonna tell you one more thing, okay? And this is gonna be effective January 1st. All right. It just beware. If moving forward, come effective January 1st, if you got tenants on housing and if it's the first time becoming delinquent in back rent, if it's their first time becoming delinquent in back rent, and their lease is valid, meaning that you have a actual valid lease for 1 year, whatever it is, you have to, you have to give them 30 days, not only to move out, but 30 days to pay their rent. That is going to be a requirement from all landlords on housing effective January 1st. That's part of the housing. They're not going to tell you this. You know why they're not going to tell you this? Because they're expecting you as a landlord to know the laws of the state of Texas and of the federal government, and they're just there to do their job, not to give you legal advice. But I'm just letting you know. Look,
Thank you.
moving forward, that's one change, and there's going to be more changes that are going to occur after January 1st when it comes to evictions. The only thing I can tell you to do, if you're not a member of Texas Apartment Association, you need to join them because they have attorneys on file and they're going to have some trainings coming up and they'll be able to tell you exactly what to do how to do it to make sure that you don't waste your time and money when it comes to these cases like we are today.
What
That's
was
on
that? What was that association?
Texas Apartment Association.
Okay.
Yeah, it's an organization. Most of the major apartment complexes and a lot of the real estate agents, they're a part of them. Or are you a licensed real estate agent?
No, sir.
No. Okay. Well, yeah, they have trick the real estate agents, but you don't. I would just get in contact with them. Texas Department Association. They have a local branch here in McLennan County, but they also have the state, and they have lots of resources that you'll be taking advantage of. It is a fee that they charge you, but you will have access to their attorneys and all of the trainings and seminars so that you can make sure that you are doing everything you're legally supposed to do when it comes to renting property in the state of Texas. That's one thing I
Okay.
can encourage you to do. All right.
I just have
Uh,
one question.
yes, Miss Johnson.
Do I have to pay the back rent in 30 days? Do I have 30 days to pay that?
He has, as it stands right now, he has to give you 30 days to move out. So yeah, you owe him because
Right.
housing, you agree with housing. You owe him. Yeah, you owe him.
Yes, sir.
And whether or not you pay him within the next 30 days or if you pay him after you move out, that's it's going to affect your housing. Until you
Yes,
pay
sir.
him, what you owe him, it's going to affect your house.
Yes, sir.
So if you're gonna move out, move out. But you still owe him that $372 for those months, September, October, now November. That man
Yes,
need
sir.
his money. All right.
Yes, sir. Mm-hmm.
Okay. What's your journey?
Okay.
Final outcome, eviction denied solely because CARES Act notice wasn't followed. Rent is still owed, the tenant must move out, and the voucher hangs by a thread. Procedure beats payment today. A brutal lesson for landlords and tenants alike. Like, comment, and subscribe for more real courtroom breakdowns and legal drama.